So moving on to our second panel session, I would like to call on our moderator, Mr. Olumide Babalola, who is the managing partner in Olumide Babalola LP. He's also a data privacy expert and a leading voice in this. Thank you so much for your time. We appreciate you being here. A round of applause for him as he comes up stage. Thank you so much, Mr. Babalola. We appreciate you. Thank you, thank you, thank you. I would like to call on Mr. Kayode Omosehin, who's the managing principal of Koriat and Co. as he joins us on stage. Thank you so much, sir, for your patience. A round of applause, please, as he comes up. And also the partner at AO2 Law, Oyeyemi Oke. If you can kindly join us on stage. If he's around, please join us on stage. Thank you so much. Also, Mr. Paul Mgboma, partner and head of associates Tayo Oyetibo LP. Thank you so much, sir. Appreciate it. Thank you for your time. And finally, we have Alicia Adefarasin, the senior counsel at Dentons ACAS-Law. Round of applause for her as she comes on stage. Thank you so much for waiting. We appreciate it. Olumide, over to you. The timer is over there. Thank you so much. I'll track Yemi and drag him up stage.
My lords, we're grateful for your lordship's indulgence and waiting for our session. We are grateful. And to everybody in the hall, thank you very much also for waiting. And to the organizers who put our session as the last session, second to the last session, we are also grateful. We are going to be very fast because of time. Yemi is online, okay. This is an issue that is not always discussed, sometimes because of the emerging technology that we are just trying to catch up with. But it is gradually becoming an issue for employers. I am not going to introduce my panelists. I'll just give them 1 minute each to introduce themselves, and then we will start proper. Please, I'll start from Alicia. Please.
Hi. Good afternoon, everyone. All protocols duly observed. My name is Alicia Adefarasin. I am a senior counsel at Dentons ACAS-Law, and I specialize in corporate commercial in general. Do advisory work on data protection, fintechs, and companies coming into Nigeria looking at investing. Thank you for having me.
Thank you very much, Alicia. I'll go straight to Kayode.
Good afternoon, everyone. Good afternoon, my lords. My name is Kayode Omosehin. I'm the principal manager of Koriat and Co., a dispute resolution law firm in Lagos. We do employment law, and we also represent clients in the fintech space. Thank you so much.
Thank you, Paul. Very quickly.
Good afternoon, my lords here present, and let me just stand on the existing protocol. My name is Paul Mgboma. I'm a partner in Oyetibo LP. I'm also the partner in charge of associates. I advise a lot of multinational companies on employment and data-related issues, and Olumide and I are always at loggerheads on a lot of issues, which we'll discuss maybe later in the session. Thank you, and I'm glad to be here.
Thank you. Can we have Yemi? Is Yemi on? Is he online? Oh, he's not. Okay, very quickly. In 2023, a principal act was passed, and this is to all of you. The Nigerian Data Protection Act was passed. Yeah, a few of us have made noise around it. We've done cases around it, but as it pertains to labor and employment, I'd like to know your opinions as panelists. Do you think this law, do you think it has been effective? Do you think even in the labor and employment space, it is just a mirage? Or do you think it is something that has started gathering some form of opinions or impression? Or how effective do you think it has been since 2023? Alicia.
Thank you very much for the question. So unlike everything that has been said today, to me, the NDPA is a brilliant piece of legislation. It's a landmark development in the legal landscape of Nigeria. I say this because it introduces new concept of law and working together. What we're used to is it just moves from what we're used to something totally different. And I give you an example. So for an HR manager in a company, for example, they're used to collecting data, they're used to storing data. What was once an administrative exercise, today what we see is that there's a legal framework around it, so how they should go about storing, collecting, and using the data. And to me, that's brilliant. You've never seen, you don't see that anywhere else. So to me, the NDPA is a brilliant act. And what it intends to do, especially in the employment sector, is to sort of give a balance between, actually, I take that back, because it empowers employees and it provides a level of accountability to employers. Again, we've never seen this before. And yeah, thank you.
I like the fact that she kept on emphasizing we've not seen that before. Before now, employees would not even be able to complain about the company's use of their data, would not even be able to ask questions around how companies use their data, or even how companies share. Now, we've seen cases where companies, after an employee has left, whether they are given, we'll come to that, so I really don't want to jump. Kayode, what do you think about the NDPA and in the employment space?
Okay, I think the NDPA is a fantastic law. It's not filling a vacuum, so to say. Before the introduction of the law, we had Section 37 of the Constitution that provides for the privacy of Nigerian citizens. Although the enforcement of that section is also another subject of different perspectives. With the advent of the Nigerian Data Protection Act of 2023, the National Assembly made robust provisions protecting the rights of data subjects. I do not personally like the description of citizens as data subjects because in India, the law there regards them as a data principal. But here, we call them data subjects. But that's another issue for another day. In my own opinion, I think the Act contains robust provisions that can assist both employees, lawyers, and even our judges in determining disputes relating to the workplace matters. I have many examples, but let me take the issue of access to records. You mentioned that before they could not ask questions, but now, under the NDPA, there's a provision, I think it's Section 34 or so, that empowers data subjects to demand from their data controllers. And data controller is defined very elaborately to include anybody who processes information, collects data, transfers data, stores data, even deletes data. Whatever you do with data, you are a data processor. So a data subject that is an employee now has a right, statutory right, to demand from his employer what information is kept. And if you analyze this section critically, it also applies to situations where employees demand for work reference. My Lord Justice Kanye decided Kevin Wangwe and...
Kayode, before we get there, so we are coming back there.
Yes, just one point on that. That act was never referenced. And there are so many cases in that line where the Nigerian Data Protection Act was never referenced, but courts took decision, to protect the interests of the employee in line with what was right. But now, and I make bold to say that with the provisions of the Nigerian Data Protection Act, our court is now enjoined, to do more to enforce the rights of citizens, not just based on the constitutional provision of Section 37, but on the robust and elaborate rights created by the NDPA. Thank you.
Thank you very much for keeping your gunpowders dry. Paul, what do you think?
Yes, on my own part, I think that, as everyone has rightly stated, the law is robust and it has made a lot of provisions about things that ordinarily were not available to Nigerians pre-2023, even though as far back as 2019, we had the NDPR, Nigeria Data Protection Regulation, which was patterned after the GDPR, the General Data Protection Regulation that is applicable in Europe. But with the advent of the NDPA, we now have a robust law on data protection and data privacy in Nigeria. But my concern is the fact that there appears not to be an aggressive enforcement of the NDPA. There is very low level of activity going on the provisions of the NDPA. A lot of employees are not taking advantage of the provisions of the NDPA. There are a lot of things there, like my friend here has talked about Section 34. There is a provision, I think Section 34 sub 1 paragraph D, that talks about erasure of data. So as a data subject, you have the right to insist that your data be erased by a data processor or collector. So, but the only person so far that I've seen that has tried to enforce that provision, even though he was not in an employment-related action, is Olumide Babalola, and the both of us are still fighting on it in court at the moment. Again, another concern I have is the fact that currently there is a dearth of case laws. There's a dearth of case laws on the NDPA, and even data privacy rights generally in Nigeria. So I don't know what the reason is. I don't know whether it is as a result of lack of awareness on the part of NDPC, although to be fair to them, I believe that so far, after they were migrated from NICDA to NDPC, the current commissioner has been doing a great deal of work to push awareness out there, but there's still a lot of work to be done. So I think I've just figured out that.
Thank you very much. Now going practical. Now, many businesses, they have CCTVs in their premises, either for security reasons, either most employers that I've even seen, sometimes the way they look at these cameras, like they... You people want to spoil my career in this place. Yes, we see CCTV, and employers sometimes use it to survey for surveillance purposes on employees, and sometimes for security purposes. Alicia, I'd like to know what you think about the privacy implications of this, and how lawyers, especially employment lawyers, can help their clients to better navigate the use of CCTVs while also staying within the compliance cycle.
Thank you. Hello? Okay. So you mentioned surveillance, right? So surveillance is not unlawful. Sorry, there's an echo. Surveillance in the workplace is not unlawful as long as it's done within alongside the principles of the NDPA, which is fairness, transparency, and there must be a legitimate interest. So employers have a duty of care, and that duty of care requires them not to mismanage the data that they process, the data that they process from the employees, the data subjects. So the NDPA emphasizes on fairness, transparency, data minimization. In terms of fairness, when you're looking at fairness, us as lawyers, we need to be able to advise employers on it's important that you let the employee know that use the example of CCTV, there are CCTV cameras on the premises, and how is that done? You do that with a notice, you do that by email, and what we've noticed in the last few years or so is that consent Commission does not look at consent as as an acceptable tool. So you can't say that you got consent from the employee and therefore you can, survey what they're doing, monitor what they're doing. That's not acceptable. What is acceptable in the employment practice, what we do in the workplace, is important that you let them know why the data is being collected, what it's meant to do, how long you're going to have it for. So I mentioned data minimization, data retention, and the purpose of the data as well. And it must not be unreasonable. So yes, you have CCTV. You can't have CCTV at places, say, at the entry and exit of your workplace to monitor how often at the entry and exit of the toilet, for example, to monitor how often how long the employee spends in the bathroom, for example. Or you cannot have a CCTV in the lunch area where they're having lunch and they're eating and you have the cameras, over them. That's not acceptable. So it must be balanced, right? I mentioned consent. Consent is not acceptable because of the imbalance in the workplace. Obviously, being an employee, you would assume consent would be assumed, if I can say so. You have to be transparent as well with why you're doing it. It has to be lawful. I've mentioned that as well. There must be a legitimate interest. So with CCTV, the legitimate interest could be for security reasons or fraud. There must be instances where you must show that there has been instances where trying to think of an example now, where there's been, an incident on the premises. So you have to show that to be able to justify why you have CCTV cameras on the premises.
Thank you very much, Alicia. I understand Yemi is around. He's online. Yemi, can you hear us?
Yeah, loud and clear, Olumide.
All right, thank you. Thank you very much. Yemi, so I'd like to ask you, I remember, I think my second year at the bar, they changed my office. I was working as an in-house counsel. And I know some law firms, some blue chip law firms still do it. And they put me in a glass office. In a pool, but he gave me a separate office, but it was a glass office. Meaning I sat down on my table, everybody could see me. I don't know why. I think the management wanted to be sure that we were working. But I'm giving this graphic example because this is the real life situation of some people. I couldn't eat, I couldn't yawn, I couldn't sleep, I couldn't blink. I felt everybody was looking at me. Now, Yemi, in the context of modern glass fittings in offices, what are the privacy implications of this? And are there issues to be interrogated? Are there advice for employers while trying to balance? Employers want to balance transparency and also, while trying to balance transparency with privacy. How do we navigate this, Yemi?
Olumide, permit me to make a cheeky comment. What were you hiding when you were placed in the glass walled office? But on a serious note, I think the issue with regards to transparency and privacy is something that needs to be considered. Again, my view is that I think there has to be what I call functional analysis in terms of the roles employee play within an organization. Now, for example, if you have an organization whereby you have various functional areas whereby perhaps because of the nature of the functions some departments carry out, there's need for what we call transparency. Now, you may have different levels of transparency in terms of what each person is expected to do. My view is that you cannot have everyone either in a glass wall or in what I call an open office. You have to do a functional analysis to be able to determine where do you put a particular employee or where employee, the employee sitting arrangement. Now, there are issues with regards to people actually even going into depression right, having panic attacks, anxiety because of the fact that they are in glass offices or open offices. So my advice or my take to employers is that when you are designing open office or you have glass walls, right, or you have the traditional brick and mortar, you just don't put employees in those boxes or in those environments without carrying out functional analysis. And the functional analysis, as far as I'm concerned, is what we call, perhaps in the privacy space, privacy impact assessment with regards to how privacy of employees would be affected in the event that you have a certain type of design. Now, there is the assumption that we always assume, that we always make to say that, oh, a transparent office or an open plan office, right, would foster collaboration. Everyone can see what every other person is doing. There is openness and all that. But the downside is even arguments around legitimate interest. The question is, how legitimate is your interest as a business owner, right, for you to be able to have that type of work design? So my view is that it's not a one size fits all, even for office designs, as bearing in mind the need for privacy. It is necessary you conduct your privacy impact assessment, perhaps before you now decide as an employer with regards to how the sitting arrangement should be. And the question some may ask is, okay, what happens perhaps to the current designs of office sitting we have, right? I'm not asking people to either go and break down whatever they have now, but in as much as you may have ongoing systems, there is need to do what I call an impact assessment, just to be sure that employers, you are not also breaching privacy of employees. So it's striking a delicate balance between maintaining transparency, collaboration, and also ensuring privacy.
Thank you so much, Yemi, for that. Now, I'll quickly move to Kayode. The National Industrial Court has at some point decided on employers' obligation to give references. Now, with the advent of data protection, there are many angles to it now. Talking about accuracy, talking about fairness, talking about transparency, talking about even the rights of the employees. I'd like you to look at that decision, yes, and please interrogate the privacy issues, the new from the Act. Now, the emerging privacy and data protection issues arising from the erstwhile armless employees reference, because now it generates more issues than we had in the past.
Thank you so much. Employee reference is about records. Before the introduction of the NDPA, we still have the Labor Act. And if you look at Section 75 of the Labor Act, it provides for an obligation on the part of the employer to keep records of employment. Those records can be assessed by regulators. And by implication, at least following the decisions of my Lord Justice Kayib in Kelvin Wangwe and Fidelity Bank, also Mukhtar Miko and Heritage Bank, I think decided by Justice Tijani, and a host of other cases. There's another case by Justice Kado. The line of authorities now suggests that even in the absence of a statute, an obligation can be imposed by implication on the employer to give reference to employees. Now, what will be given is what I believe this NDPA has now robustly provided for. The principles enunciated in Section 24 of the NDPA are very sacrosanct. The fairness that my colleague spoke about, the issue of consent of the employee, particularly where a prospective employer or a new employer is asking for a work reference from an old employer where the employee is not even aware. It's important that an employer should ensure that they get consent of the former or existing employee before releasing their records. Also, it's also important to note that whatever the employer decides to issue in form of work reference must be accurate. There's a provision for accuracy under Section 24 of the NDPA. Information must not be misleading. This is what my Lord Justice Kanye decided in the Kevin Wagwe's case, relying on English authorities, saying that it must not mislead the public or the recipients of the reference. Now, in addition to that, it's also important for employers to decide whether whether the recipient of that reference is a local entity or person. If the entity receiving that information is overseas, then it brings another additional obligation under Section 42 relating to cross-border data transfer. And there you will find that there are additional requirements that an employer must fulfill, particularly making sure that the receiving party is subject to a data protection law in its host country, or if there is no data protection law, there is a binding corporate rules, or there is a code of conduct, or there is a certification mechanism that provides adequacy or adequate protection that is similar to what is provided under the NDPA. It is very important for employers to be guided. And now, employers must also have in place what we call data security practice or data protection practice. This is what my colleague was referring to when she said, if you have CCTV, you must ensure that you also have policy backing it. In addition to that, you must have notices. But beyond that, in the event of data breach, and in the event of data breach, let me break this down. Where, for instance, using the case of reference that you asked me, reference about records of employee should be given to, or should be processed, or should be, prepared by those who are saddled with that responsibility. I mean the HR. And now, even among the HR, it is not everybody who should know about the records of a data subject. And in releasing it to recipients, the channel of communication also should be protected to guarantee the confidentiality of the information contained in that reference. And just final point, minimalization. The information required or requested should be kept to the barest minimum. I think there's a case decided in this country where questionnaire was provided for employers to answer. Rather than answering the questions listed, the employer decided to write a letter indicting the employees, stating numerous allegations regarding outstanding debts, which eventually made the new employer to terminate the employment of that staff. That led to a litigation that eventually exposed the business to liability, and that should be avoided. Thank you.
We are pressed for time. Before I come to Paul, I'd like to throw this to the audience. Depending on, for me, I think there are no right or wrong answers depending on what angle of the divide you are speaking from. Now, an employee leaves company A, goes to company B. Company B asks company A to provide reference. Company A provides reference, whether favorable or not. Now, the employee wants a copy of the reference. Can the employee actually ask the former company for a copy of the reference? Very quickly, sir. What do you think? No? Context. I'll come back to context, sir. No or yes? Okay, context too, yeah? Yes. Okay. It says no, it says yes, it says context, it says what I mean. Okay, let's hear your context, please. Very quickly, in like just 30 seconds, so that
Recording
I have a last question to ask and then.
So simply because my information
Yes,
is
please.
what is being transmitted here.
Yes.
Yeah, I give the context I'm saying is this. For example, I get in a new employment. I'm supposed to take medical test. The office says, or the employer says, I must sign consent form to be tested. I sign the consent form. Now the information goes to my employer. I don't have what the hospital has, and I ask the hospital, where is
That's medical, that's not
no.
reference.
See, we are talking.
not
No.
reference.
It's not reference. But what we are talking
I
about,
actually asked a question about
information.
medical,
It is
yes?
information about me.
Yes.
Exactly.
Okay, so
It's
I'll come
information
back to
about me.
reference. No, so from the former company, reference was given to the new company. Now you want to know the content of that reference. Can you legally, validly ask the former company? You are squeezing your face. Okay, now we continue. Please, Paul. Now, lastly, we should save time. That's good. Lastly, what advice would you give employers to proactively build trust regarding their data? Because we've spoken about data. Mr. Gwenga has spoken about sharing even medical, and these are a lot of things that go on in employment. I asked some company that I trained their staff, and I asked them an innocent question that, I mean, they should just be honest with it. Do they really know how the companies process their data? And a whole lot of them said no. Maybe in the past it was not. You couldn't question your employers about certain use of your data, but maybe the law is changing now. So, what advice do you have for employers on how to build trust amongst their employees with their use of their data?
Now, I think the starting point will be the fact that quite a number of employers are yet to understand the fact that they are actually data controllers under the provisions of the NDPA. If you look at section 65 of the NDPA, which defines who a data controller is, it says an individual, a private entity, a public entity, a commission, agency. So clearly, even as an individual, you are regarded under the NDPA as a data controller. So clearly, you are under the law required to have some privacy policies. So there is need for not just lawyers, but also other employers to ensure that there is that synergy between their legal department, for companies that have legal departments, or if for law firms, the lawyers in the office, IT department, and HR to come up with data privacy policy. It is in that data privacy policy that they will state what would be contained as to how information is collected and managed or processed of the data subjects. Because if you look at, for instance, there is no organization that does not have anything whatsoever to do with data.
Yes.
Right from the time of employment, your data is collected. They will ask you your name, date of birth, and all that, okay? Even when you leave the employment, your data still remains with them. So it is the data privacy policy of the organization that would state what your data will be used for and how it will be safeguarded or protected even after you've exited the organization.
Thank you very much. Just 1 second each. 1 minute each. Your parting shot, because we are pressed for time. We need to get out of here as quickly as possible. I'll start from Alicia, please.
Okay, so in terms of surveillance is not limited to CCTV. You can also monitor your employees via email, internet usage, and so on and so forth. I wanted to make that clear that it's not limited to CCTV. Now, monitoring must be fair, right? And it must not outweigh the employee's right to to privacy under the Constitution. So monitoring must be fair, objective, and without discrimination in making decisions about the employee's performance, promotion, and anything to do with the workplace. So you must be honest to your employee as to why you're doing it. Would it affect their performance? And if so, what are the measures in place? What are the measures you've taken in place? Sorry, you said parting words. So just to quickly close up, right now, data protection is a major issue, and we've seen compliance with, multinationals and indigenous large firms within Nigeria. So I would encourage smaller companies, SMEs, and other companies to take data protection seriously. The Commission is coming down on companies that are not regulated, so the likes of companies in the banking industry or companies in the telco industry or fintech. They're coming down strongly on them, and we can see enforcing compliance in that space. So
thank you.
Just be ready, be prepared, get a DPO, reach out to your lawyers to find out what are the laws that apply to your industry and how you can apply them, especially in relation to NDPA.
Thank you very much, Alicia. We saw just about last week, MultiChoice was fined. Before that time, we had Fidelity, we had Meta, and it keeps going on. So, I mean, the regulatory expectations now are even bigger on data protection. Kayode, your parting shot in one minute, please.
Okay, so my comment is on the enforcement of the rights under the NDPA. I think it is becoming increasingly difficult to enforce data protection rights, particularly by employees, anywhere else, apart from the Federal High Court. And I say this because if you look at the trend of cases that have been reported, you will see that most of them have been enforced under the Constitution as a fundamental right rather than a right under the Act. The Act provides for penalties for violation of data subjects' rights up to the tune of 10 million naira that can be imposed by the Commission created to implement the provisions of the Act. Although the Act does not provide for monetary the quantum of damages that could be awarded, to a victim of data breach if he's an employee. But I challenge, the stakeholders, particularly lawyers, and my Lord's judges present here, that we can derive inspiration from the penal provision, creating sanction, creating fine, against those who violate the provisions of the Data Protection Act in assessing what should be the quantum of damages to be awarded to a successful claimant in a data breach claim. In addition, I want to encourage the lawyers, and I do not think focusing on constitutional rights under Section 37 is the only way to enforce violations of privacy. We can enforce rights under the NDPA, and it makes it more difficult for a defendant to escape liability because of the principles that are enumerated in Section 24 and additional section requirements under Section 42 for cross-border transfer of data. So it's important for us to get ourselves abreast of these provisions so that we can do justice and advise our clients accordingly.
Thank you very much, Kayode. Paul, please.
I'll just start by making a little comment on what my brother here has said. So, with respect to the issue of enforcement, now if you look at Section 25, sub 1, I think paragraph 5 of the NDPA, it makes provision for legitimate interest. That is that data controllers or data processors can obtain information, data subject information for legitimate interest. It then goes further down to talk about instances where the data subject can enforce rights that are incompatible with that legitimate interest. And one of those rights is that you can institute an action for fundamental, where the a legitimate interest conflicts with fundamental rights. So just to add that it's not only under Section 37. So it's just that, like I said, there appears to be some lack of awareness about the robust provisions of this law. So lawyers need to take advantage of it. So clearly that provision is one. Then my final shot is that there is need for employers to be well guided in the manner they manage data processing of data subjects who are employees, particularly in recent times where we now have what we call BYOD, bring your own device. We see that the lines have now been blurred between when an employer gives, for instance, gadgets to an employee to be able to work, and when an employee brings his own gadgets to be able to do work, and the employer then insists on installing some apps, for instance, that is used for time logs to know, okay, this is the amount of time that you have used to advise certain clients, particularly for clients that you have to bill in dollars and then you have to charge per hour. And then there are also location apps that can be installed on devices to monitor, okay, if you say you are going for a meeting, you have to log in, and those apps actually report your location. Those apps actually collect your data, and at the moment, we don't know, okay, do they sell where the servers of those apps are? Clearly, they're not in Nigeria.
Yeah.
So where those servers are, do they sell those information to other people? Particularly, for instance, you see a situation where we now have a situation where you look for something, for instance, online, and then before you know it, when you open the particular, let's say it's Safari, adverts on that particular thing that you checked would then begin to pop up. So
Thank you, Paul.
So
Thank you.
I think there's need for that.
Thank you very much. Now, I quickly go to Yemi before we end the session. Yemi, please, your parting shot in 55 seconds.
I will try. So I think the parting shots for me is that there are three things that we should, or I would implore in terms of what are the rights of employees, what are the obligations of employers, and perhaps on the area of jurisprudence. For employers, one thing we should, or employers should bear in mind is that data protection issues have come to stay, and they are quite tricky, extremely tricky, and you need to pay attention to these issues, or else you may find yourself in a situation whereby you are exposed, one, to the regulator and also to the data subject, and perhaps ultimately you may also have reputational issues. So it is an issue that is sensitive, and more attention should be put to data protection issues. Now, on the side of the employees, the point would be that you have more rights. There are certain things you can now ask of your employers not to do, and you have every right, legitimately so. So you should also ensure that you either guide or raise privacy issues to your employers from time to time. You have data subject access requests. You have rights to ask for certain things which are enshrined under the NDP Act. And on the third part is that, which is the jurisprudence. We are in early days of the NDP Act. It's just about roughly about 2 years. Jurisprudence needs to be established or needs to be expanded. And perhaps what we should see more should be more actions either by one, data subjects, two data controllers, and sometimes by regulators. So I think those are my parting shots, Olumide. And thank you.
Thank you very much. Thank you very much, Yemi. My lords and the distinguished, that's the end of our session now. Thank you very much, my lord, and thank you very much for waiting.
No. If you can sit down. I'm sorry. You know when you are in court and there's one more case, you can't leave before that case is done. So just bear with us. We just have a few words from someone who wants to add to this conversation, who will join us on stage. You can have Mr. Lateef Oyeyemi Oke, Senior Advocate of Nigeria, kindly just join on stage very quickly. is here. And Nonso, if you can please, you can come and take over from here. I don't mind. I will leave you on this podium. If we can have that conversation very quickly that way, sir. Thank you so much. And then we'll have pictures all together and we'll round up. 5:45 is what I had promised, and I'm trying to keep to that.
Thank you very much, our distinguished MC. And I have to stand on the existing protocol, so just for the sake of time. We would have loved to be more detailed, but we are running out against time. I want to thank all attendees, and this is actually the last. Yeah. What's that name? Okay. Okay. So the last session, panel session 3. We have two legal giants, two distinguished senior lawyers. One of them is Senior Advocate of Nigeria, Mr. Oyeyemi Oke, who is already seated. And we also have Mrs. Oyekonsola Badejo Okusonya, who unfortunately, she was here in the morning, as we all saw, but she had an emergency, and she had to send someone. And the representative is here, someone from her firm. Please, you are welcome. Yes. Can we have a round of applause for her? Okay. At the right time, we'll call upon you. Yes. Yes. So, we want to wrap up this session or this conference on a very interesting point. The National Industrial Court has done a lot in uplifting the interest and the rights of employers, and to some extent protecting employees and employers. But now, as legal practitioners, someone mentioned something to me in the morning and say, a lot of people who come to NIC, practicing lawyers, are not well versed in basic, he used the word advisedly, basic employment and labor law. And why don't we have most of them here today? So now we are drilling down to the role of legal practitioners in beyond statutes, beyond the law, beyond what the law has said, beyond the Labor Act and other laws. What can we as lawyers do to ensure that the rights of to advance employment rights in Nigeria? So we have actually drafted some questions and how this panel will go, but because of time, I will start with the Leonard Silk, please. And my question, feel free to divert as much as possible, particularly on the issue of what NBA is going to do, because charity begins at home. Lawyers go to court to canvass this right, but when we look inwards at the law firms, at our organizations, what are the things that you think what specific strategies would you recommend for legal practitioners to advance employment rights, particularly as it relates to vulnerable groups such as women, youth, and informal sectors? And please, if you can take it a step further, as an organization, do you think that NBA has done what it should do beyond the law, beyond reciting the laws, beyond going to court in protecting employment rights in Nigeria? Thank you.
Yes, thank you very much. Good evening, everyone. Given the time of the day and that time is fast spent, I think it would be wise for me to just stand on the existing protocols, because I know that attention span, it's gone far down. In fact, I was contemplating which side the balance of convenience would lie now, taking this session or allowing people to go, having stayed for this long. But I think the preponderance of evidence is on, listening, allowing us to say a few things. And I'll just say, very briefly, I think there is no gain saying that the National Industrial Court today is the most progressive, most purposeful, and fastest growing court in Nigeria. And I think, the lordships deserve a round of applause for that. Now, I always say that when my friend and brother Inam Wilson saw me today, he said he didn't know that I practice employment law. And I said, well, the last time I checked, Inam, I am a commercial litigator. Unless you say employment law is not within commercial anymore. So, but that speaks to something. It speaks to the fact that employment law, labor law, is an aspect of law. It's a species of law. And which requires specialized skills. And one of the things we, and I myself, always advocate at gatherings like this, when we talk to colleagues, either at the MBA level or whatever level we meet ourselves, I always talk about lawyers diversifying their skills. So diversifying your skills would mean that not everybody would do the general civil litigation as we know it. You know, some people would focus. Some people would have seen the juice in labor and employment law. People like Falabi Kuti would have keyed into it a long time ago and milk that area. And that's why Inam was surprised that we want to join them or we're there. But more importantly for us as lawyers is to understand that one of the first things you can do to yourself as a lawyer is to acquire knowledge. So you got to understand, you got to adapt with the developments at the National Industrial Court. Understand that the Constitution, Section 254, has given them the jurisdiction that says that notwithstanding anything to the contrary, in the Constitution, and that they would have jurisdiction to do A, B, C, D, E. If you look at 254 all the way down, you see that, including applying international conventions, whether or not it's been domesticated, they can't do that. And once you are abreast of that, you know that these provisions have been tested, because I've come across several, arguments and several situations where lawyers have argued that, Section 12 of the Constitution says that, international treaties must not only be ratified but also be domesticated. But if you look at the decision of the president of the National Industrial Court in the Aero Contractors case, it's put it to rest that the wording of Section 254 says, notwithstanding anything to the contrary. And if you go and look at the AG Lagos and AG Fed over VAT matter, a case in which I was privileged to be one of the counsel in it, where Lagos State went to the Supreme Court via the original jurisdiction of the court, being a case between the state and federal government. And we said, and we were inviting the Supreme Court to invoke its jurisdiction under Section 232, original jurisdiction of the court, to take the dispute between Lagos State and the federal government over who has the legislative competence over VAT. And Supreme Court wasted no time in saying in that case that Federal High Court is the appropriate forum for you to go to. That notwithstanding the fact that the dispute is between federal government and state, which 232 says, yes, you should go to the Supreme Court.
I'm sorry, please, can you round up in 5 minutes?
Yeah, sure.
Okay.
Of course, I will. But it says that...
2 minutes, okay.
It says that the notwithstanding in that case, in 251, means that it doesn't matter what 232 it displaces. So we all know that 254 displaces Section 12. So now, in formulating your strategy as lawyers, once you are aware, and you've seen the progress made in that court, using international best practice from its decisions, you know how to formulate your case, you know how to advise your client, so that you don't waste time of the court on technical appeals and all of that, which is what wastes a lot, majority of our time, of the time spent in court. If you look at almost half of the matters in the Supreme Court, they are on technical grounds, they are interlocutory appeals. So those days are gone. Understand the court, understand where the court is, understand that it's one of the court that is the e-filing system and all of that. Very soon, I'm sure my Lord will get to e-service and all of that in that court. So lawyers must be abreast of where the court is and do that. And there is no substitute for learning. We say that the NBA, even ELAN, these are the bodies that should continue to push the boundaries of labor law by organizing training and learning. The ICLE is one of the things that the NBA should do, give that training to lawyers who practice in this area of law, so that they are abreast of what goes on, what obtains right now, and they can advise their clients and also be as NBA as pressure group should sit with the National Assembly. Most of these laws, when they come, is after they've been passed that.
Thank you, Leonard Silk.
Yeah.
Thank you, Leonard Silk. Thank you, Leonard Silk.
But if we take a proactive approach as Airline, as NBA, work with National Assembly, most of the laws are outdated, bring them up to speed, and I think that would be a way forward. That's one of the ways lawyers will continue to.
Thank you very much. Thank you very much, Leonard Silk. We have a lot to say. And one interesting point I've taken there is that lawyers have not done enough. You know, lawyers are still constitute some clog in the wheel. So I'll have to ask Mrs. Atilolua Taiwo Nsirim, who is a senior associate Africa Law Practice NG & Co, representing Mrs. Okusonya Badejo. Please, what do you think, practical issues, what do you think are the major impediments that lawyers, legal practitioners face in upholding employment rights in Nigeria? Not theory, practical things that you think. Do you think is an issue of apathy amongst lawyers? Or do you think it's an issue of lawyers holding on to technicalities even when they know that the era of international best practice has come? Can you share your perspective on these challenges? And we can wrap it up on that.
Thank you very much, Nancy. Good afternoon, everyone. I stand on all existing protocols. Okay, thank you. I stand on all existing protocol. My lords here present, I do extend my apologies to everyone present for Mrs. Badejo Okusonya's absence today. She was here earlier, but an emergency came up and she had to leave. Thank you to the organizers of this conference for the opportunity as well. In terms of the impediments that lawyers do face in the enforcement of legal rights, I think one particular thing is the fact that there is a lack of will with the employees. And it's not a lack of will that is created by anything other than the fact that they are unable to push litigation beyond certain levels. Now, when most employment lawyers, and I think that members of this body would confirm that many employees' cases are usually taken on a pro bono basis or on a success fee, contingent fee basis. And that's because most of the time they do not have the capacity to fund litigation to enforce their rights. So I think this is one major impediment to the enforcement of employment rights in Nigeria. I must commend the leadership of the National Industrial Council, the court, I'm sorry, the NICN. Indeed, the judges have made remarkable judicial precedent cases. However, there's still the need to do more, and we pray that many of the judges currently at the NIC are able to rise to the Court of Appeal so that there is knowledge present in the court in terms of employment and labor-related disputes, so that the quality of the Court of Appeal judgments that are handed down are not such that take us back pre-1979. So these are some of the impediments that we face in the enforcement of employment rights, and I think that there's still so much to be done. I think I've been able to answer that question as best as I can. Thank you very much.
Thank you very much. It's just unfortunate that we have to wrap this up as fast as possible. But one thing about airline is that we are not supposed to say this, but the point is that we know that Leonard Silk, Mr. Oyeyemi Oke, and Mrs. Okusonya Badejo, they have an aspiration. I don't know what that is, but in the right time, Airline on Record was the first organization that brought about the people that have this national aspiration on a platform to discuss this issue. So we will make this a subject of that discussion in due course, because we have to interrogate what MBA is doing, what law firms are doing. There are still law firms who don't give employment contract in this Lagos. I can name some, but I'm not going to name some. There are lawyers who work without employment contract in Lagos, as we're speaking. There are lawyers who don't have a fixed salary. The managing partner wakes up this month and he gives them 300,000. Next month he gives them 250. It depends on the whims and caprices, or on his mood or her mood. But that's a discussion for another day. So thank you, Mr. Kongwe, Leonard Silk. We will call you back in due course. We have noted your aspiration. And we have to also thank Mrs. Okuson Badejo. In due course, all the aspirants, so to speak, I have not said anything, all the national aspirants, it could be National House of Assembly, but we'll call them back to interrogate them more because NBA must get better. Thank you very much.
Thank you so much, Nonso. To my previous panel, now we can take the pictures. My lord, if you can kindly please join them on stage for the pictures. We are at the end.
Good evening, ladies and gentlemen, my lords, distinguished guests, esteemed colleagues, and honored participants. I'll make this very fast. We thank you for everyone that's come here today. As we gather here today to conclude this conference, book launch, and 10th year anniversary, I would like to take a moment to express our heartfelt gratitude to everyone who has made this occasion possible. To our keynote speakers, panelists, and presenters, thank you for sharing your expertise and insights with us. Your contributions have enriched our understandings and sparked meaningful discussions. To our organizers, volunteers, and support staff, your tireless efforts have ensured the smooth execution of this event. We appreciate your dedication and hard work. To our sponsors and partners, all the gold sponsors, bronze sponsors, silver sponsors, and all those who contributed even with their presence alone, all those that placed advertisement with us, your support has been most invaluable, and most definitely, this event would not have happened without you. We are grateful for your trust in us, and look forward to continued collaboration. And to all attendees, your presence has made this event a success. We hope you found the discussions informative and engaging. As we part ways, we look forward to staying in touch and building on the connections made here. Thank you once again for your participation and wish you all the best. God bless.